Counsel, thank you for coming forward the way you did and getting ready. That may save us a few seconds. Now's the time set for oral argument in cause number 1, CA TX 150007, Loma Mariposa 2 LP versus Santa Cruz County. For your information, these proceedings are being both audio and video recorded, and you had to sit here while we reset it, so you're probably aware of that. So barring any unforeseen problems, you'll be up on YouTube in a couple of weeks. Enjoy. The counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to preserve or reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and help you avoid taking up all that time. However, ultimately, your reserving of rebuttal time is up to you. We have reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument, and the only reason we say that is so it'll give you some kind of an idea of, having read the briefs and things, where you can best focus your 20 minutes. Counsel, when you come to the podium, I would ask that you state your name and who you represent, and with that, the appellant may begin.
Thank you, and may it please the court, my name is Roberta Livesay. I'm here representing Santa Cruz County. The tax court ruling in this case basically punishes Santa Cruz County for a mistake made in mailing its notice to the appellee. But the burden of the punishment imposed by the tax court will not fall on Santa Cruz County. Instead, it falls on all the other taxpayers within Santa Cruz County, who are basically strangers to this action. And the only one who benefits from the tax court's ruling is the appellee. It's necessary to understand that property tax is not like any other tax. With income tax, with sales tax, with any other kind of tax imposed by the government in the state of Arizona, if the taxing authority receives less from its collection that it had planned on receiving, it simply has to make do with less. But with property tax, there is a certain amount of revenue that is raised according to the budgets that are passed by each of the taxing jurisdictions, school districts, the fire districts, the flood control districts, the county itself. And those taxes will be raised. If one taxpayer benefits and gets a windfall tax refund, as in this case, that shortfall will be made up, and the county will not pay any of that burden. It will instead be made up by the remaining taxpayers.
Counsel, isn't that the case any time that there's a statutory requisite, a requirement of statute, and as in this case, the county or the obligor under that statute fails to act according to it? I mean, that is what happens when we impose the law, correct?
No, Your Honor, not in every case. When you have an income tax provision, for example, and the government does something that stops it from collecting someone's specific income tax burden, the government simply has less revenue to deal with.
Isn't that the legislature's responsibility to fix if in fact it's a problem?
Well, the reason I bring it up, Your Honor, and I don't usually do it, but the reason I bring it up in this particular case is because when you look at what actually happened here, and when you look at the case law that appellee is relying on, it's very important to keep in mind the policies that are at play in the property tax system itself that are not at play in these other systems from which these other cases originate.
So the policies are more important than the language of the statute?
Not at all, Your Honor, but this is a statute that has not been interpreted ever in the way the tax court has interpreted it. And what you have to keep in mind also is that this particular taxpayer, the appellee here, has not suffered any prejudice, any harm whatsoever by the mistake in the mailing label. The taxpayer here...
They did not receive the benefit of the statute.
they received the benefit of the error correction statute, 100% of what they asked for. They asked for 4 years of property tax refunds, retroactive refunds, and that's exactly what the tax court has given them in the nature of a mandamus order.
And that's because the statute mandates a particular procedure. The procedure here was when Santa Cruz County did not timely respond, the statute gave a benefit to the taxpayer. I don't see what's wrong. Well, I guess I have two questions. A, I don't see what's so wrong about that, and B, that may be bad policy. But that's not our concern. Our concern is following the language of the statute. I mean, by what law can we disregard the language of the statute?
I'm not asking you to disregard the language of the statute, Your Honor. I think if you look at the statute specifically that they're relying on, it's 42-16254C. And they look at the first sentence of that statute and say, stop there. But that statute has two sentences, and the second sentence says this: a failure to file a written response within 60 days constitutes consent to the error, and the Board of Supervisors shall direct the county treasurer to correct the tax roll on the taxpayer's written demand, supported by proof of the date of the notice of claim and the tax officer's failure to timely dispute the error. That happened here. This taxpayer sent a demand to the Board of Supervisors threatening a mandamus action if the board didn't instruct the treasurer to issue the refund. The board didn't instruct the treasurer to issue a refund. Instead, the assessor, seeing that demand, realized it had made a mistake in the mailing, and the assessor said, here's our denial. We're sorry we made a mistake. Please go to the Board of Equalization now to have your substantive concern addressed. And the taxpayer here withdrew its demand for mandamus and went to the Board of Equalization, and the Board of Equalization did hold a hearing within the statutory time frame and ruled on the substantive issue that the taxpayer was concerned about.
It goes to your waiver requirement.
It does, and it goes to the mandamus requirement. Mandamus is really required by the statute.
Isn't it sort of like you have 30 days to file a notice of appeal? You wait to the 40th day. You file the notice of appeal. The other side doesn't notice it in their answering brief, doesn't move to dismiss the appeal. We notice it, and we can say, oh, Pelley waived the argument. Isn't that what you're sort of like what you're saying?
That is sort of like what I'm saying, Your Honor. And here's another distinction between this case and the DES and the Stapert cases. In those cases, which is what the appellee relies on, what the tax court relied on, the person who made the mistake went to those boards and said, hold a hearing. I made a mistake in getting my notice here, but hold a hearing anyway. And the board said no. Right. But here the board said yes. The board held the hearing. It held it within the statutory time frame required from set in motion by their original petition for correction of error.
But, counsel, if the statute requires a time procedure, a timely filing the notice to the right person, just like the statute or rule says you've got to timely file a notice of appeal, and for instance, on a notice of appeal, the court can't say, oh, well, we'll give you a second shot. We'll let you file a delayed notice of appeal because the other side waived it, or because, gee, it wouldn't be fair to let you do that. So we'll give you a chance to argue this on appeal. Can't do that. I mean, my point, when you sort of agreed with me.
Well,
maybe you want to withdraw that. But.
Well, I sort of agreed with you, Your Honor, but what my sort of agreement was based on is the line of cases that we cited in our brief where courts do exactly that, where there has been excusable neglect, and the courts looked at the substance of what really happened there and weighed the benefits and the harms.
Sure, but for instance, I mean, usually you have something, either a statute or a rule that allows for excusable neglect. I don't see that here.
But you do have that here, Your Honor, and that's why I'd ask you to take a look at 162.54C, where it says exactly what the remedy is if the assessor fails to deny the consent. 42162.54C.
Same statute we've been talking
The
about.
same statute I've been talking about, but the second clause of it. And you can't separate that second clause from the first part. The remedy here to the assessor's alleged consent is a mandamus action. It comes right after the failure to file the written response. And I can't remember if I said this at the beginning of my argument, so I want to say it now, but I'd like to reserve at least 7 minutes for rebuttal. The Board of Supervisors is supposed to direct the county treasurer to correct the tax roll, and the refunds proceed from that correction of the tax roll.
But the second sentence says, failure to file a written response within 60 days constitutes consent to the error. The Board of Supervisors shall direct the county treasurer to correct the tax roll on the taxpayer's written demand, supported by proof of the date of the notice of claim and the tax officer's failure to timely dispute the error.
Correct. That really is an instruction of what the duty of the Board of Supervisors is, what the duty of the treasurer is, and the failure to comply with that duty is a mandamus action. It's not a trip to the Board of Equalization to look at the substantive issue.
But again, you're getting to the idea of waiver,
Exactly.
not to what the statute requires.
No, Your Honor, I'm saying you can't look at the first part of that sentence in a vacuum. You have to look at the entire sentence.
Are you asking us to look at the second sentence and ignore the first?
Not at all, Your Honor, because the second part of the sentence flows from the first, okay? We'll take it as a given that all the other facts of this case put aside, if nothing more had happened, but the assessor mailed it to the wrong address, nobody realized that until after the 60 days had passed, that this appellee would have been able to go to the Board of Supervisors, as it did, demand that the treasurer do what the statute says, and would have gotten its refund. And if the board hadn't done it and the treasurer hadn't done it, that this taxpayer could have come to court and asked for relief in the form of a mandamus order directing the board to do what the statute says. But that's not what happened. This taxpayer said basically, oh, never mind, Board of Supervisors, I will go to the Board of Equalization instead and ask the Board of Equalization to deal with my substantive problem. The board held a full hearing on them, accepted their income approach evidence, and said, no, we don't agree that an error has been committed. We deny your petition to correct the tax roll.
And then the taxpayer goes to the court and says, listen, not only are they wrong in the merits, but they're wrong because they should have just corrected this under subsection C.
Correct. And the county maintains that having gone to the Board of Equalization, the taxpayer is now limited to look at the substantive error. They still can have their day in court. I'm sorry, Your Honor.
Where do we find that? Give me a statute that says if the taxpayer does not do X, then it wipes out the failing of the notice requirement, the 60-day requirement.
It's in that same error correction chapter, Your Honor, and I have outlined it in my brief. It says a taxpayer who's dissatisfied with the decision of the assessor can go to the board. And here the taxpayer said, I'm dissatisfied with the decision of the assessor denying my substantive claim. I'm going to the board. And then, having been dissatisfied with the decision of the board, the taxpayer gets to go to court. And all the county is saying is, let him have his day in court. We're not saying take away his right to prove his claim. We're saying he should have the right and the burden to prove his claim, and the county will meet his claim on the merits in the tax court. He hasn't been foreclosed. He still has a remedy. He just doesn't get mandamus because he waived it. And that's where I think it's important to look at those other cases that the appellee relies on and that the tax court relies on and says, well, they're not really addressing the same public policy here because the burden of the mistake there falls on the one who made it. Here, the burden of the mistake is falling on other taxpayers who are strangers to this action. Let this taxpayer have the right to plead his case on the merits. Don't foreclose the county from raising a defense. And unless the court has other questions right now, I'd like to reserve the rest of my time for rebuttal. Thank you.
Good morning, or good afternoon, probably now. My name is Douglas John. I'm with the firm of Buckhalter Nemar, and I'm here on behalf of Loma Mariposa 2.
Mr. John, if
Yeah.
you don't meet the 60-day requirement, if the county doesn't meet the 60-day requirement, do they then get kind of a bye so that they then can argue the merits that they would have argued if the 60-day requirement had been met?
No. If they don't meet the 60-day requirement under 42-16-254C, they've consented to the notice of claim under the statute, and that consent is unconditional. And that's held up under Hormel. In the Hormel case, the taxpayer filed a notice of claim seeking reclassification of the property. The assessor and the taxpayer met, and at that meeting, the county granted the change in classification. Subsequent to that, no refund had been issued, so the taxpayer followed up with the county to inquire as to what's the status of the refund. And it was only then that the taxpayer found out that in fact the county was going to renege on the granting of the error correction. But by that time, it was 198 days past the deadline for the taxpayer to file an administrative appeal. And the Court of Appeals pointed that out, that due to the delay on Maricopa County's delay in answering that, they had essentially deprived the taxpayer of any kind of administrative review. So in Hormel, the only avenue they had at that point was a writ of mandamus against the county, and they filed it. But the court held that because on appeal, Maricopa County argued that because the underlying merits of the notice of claim were not in fact true, they really didn't qualify for Class 6, that therefore their consent was void. And as a result, the Court of Appeals in Hormel said no. Once you've consented, the consent is unconditional, and you can't go back and relitigate the underlying merits of the case. And much of the briefing on the part of the appellant is focused on that, trying to relitigate the entire merits of whether or not there was an error correction or not. And in fact, we've addressed that throughout our briefing, that in fact that the errors that we have alleged are actual errors.
So do we have to reach the merits to say that the merits of whether there was an error in order to rule on whether the consent, whether you were entitled to the relief based on the consent on the error under subsection C?
No, and Hormel says you can't. Hormel says once they have consented, you don't go back and unwind it and litigate the underlying merits. That was an argument that was made by the appellant in the tax court and in Hormel.
And the consent is by default, effectively.
Yeah, yes, they said it's as the court said in Hormel, it's unconditional at that point.
When you didn't get relief from the board, shouldn't you have done mandamus action right then and there?
Because we didn't get relief from the reason we pursued the appeal to the Board of Equalization is because we realized we had both a claim with regard to the actual merits of it and with respect to the consent issue. And we didn't want to be put in the position of having filed directly to tax court, and if we had lost on the consent issue, then our appeal rights with regard to the administrative appeal, or excuse me, with regard to the merits, that would have been foregone at that point.
I'm confused. Why couldn't you go to the tax court for a mandamus and still filed your appeal and say, if the court doesn't order a mandamus, we want to proceed?
Mm-hmm. Because the statute only allows 150 days
Right.
in which to file
Right.
an administrative appeal.
But why can't you do both? I mean, in other words, let me give you an example that I'm more familiar with.
Okay.
You get a final judgment in a child custody matter. You know you can file a notice of appeal. You file your notice of appeal, but you say, I really want a special action because an appeal can take 2 years. So I file a special action, and in the special action I say, I've also filed a notice of appeal. So I'm doing both at the same time because I need a faster determination of that rule. You do both. You preserve it both ways by, one, filing with the tax court, and while that's pending with the tax court, filing and going through the rest of the process and saying, if the tax court rules against us, we want to go through the administrative appeal route. Why couldn't you have done that?
Well, there's always the concern with respect to would we be able to get that done in time. But the larger issue is here that the property tax statutes and the notice of claim statutes require us to exhaust all our administrative remedies in this case.
Okay.
And so that's why when we filed to the Board of Equalization, we filed both on the substantive claim as well as on the consent. The hearing, in fact, was mostly on the consent issue. It was very little.
That's not what the statute calls for, right? As I read subsection C says, here's what happens if the county makes a mistake and doesn't timely file or send the notice to the proper person. And then D, E, and F and G talk about, okay, if the tax officer disputes the error, they notify you of a time and place for a meeting, you have a meeting, and then if they fail to agree on a meeting, then you can petition the Board of Equalization. And then if you're dissatisfied with the board, you can appeal that decision to the court within 60 days. I don't quite understand why the consent issue went to the Board of Equalization.
Because we were trying to keep both claims together, and then it eventually went to the tax court. The tax court heard the consent claim, heard the merits of it, and determined that they had in fact consented.
But you were trying to avoid a claim later that you failed to exhaust your administrative remedies?
Yeah, because that would be the argument we'd be here arguing today, that if we had gone directly to court.
Okay.
But as Judge Kessler pointed out, there's a reason why you couldn't have done them both at the same time. At least I'm not aware of anything.
Well, again, in property tax statutes, the general emphasis is to exhaust your administrative remedies before going to court. And so we were trying to preserve all our rights. I understand that, yeah, in theory we could have bifurcated, I guess, the claims. But there probably would have been an argument that if we, on special action, if we filed special action, that we're foregoing our claims on the administrative end of it as well.
So I guess what you're saying, I'm not trying to put words in your mouth.
That's fine.
But I guess what you're saying is usually when you have a waiver of a right, there has to be a knowing, intelligent, voluntary waiver.
There's no
none
evidence
here.
of
There's
that.
no express waiver, even implied waiver here.
No, quite to the contrary. Throughout the whole case, we actively pursued all our remedies, both at state board
And you
with-
constantly raised the consent issue
Absolutely.
on each level.
Absolutely. There was never any intention to waive anything. Again, it was just caution of trying to preserve all our rights and ensure they were preserved. And the tax court, who heard all this, their conclusion on the waiver was essentially there was nothing to waive. There was no waiver at all. And that, in fact, we had shown that we pursued all these remedies. One issue raised by the appellant is that on the issue of consent, when they fail to respond within the 60 days, the 60-day deadline, that there is a good cause exception, or there should be a good cause exception for late administrative filings. And that's clearly addressed in Stapert versus Arizona Board of Psychologist Examiners, where they said that unless there is an explicit provision in a statute or rule that there's a good cause exception, you shouldn't read one into it. And there is no such language in this case at all. They can be construed that. Judge Whitten didn't find that either. And there really are no good cause exceptions for late filings if you look throughout the entire property tax statutes as well. Most of that burden falls on taxpayers. If taxpayers file late, there's no good cause exception for filing late. And nor would you want to read one in there, because that will just simply lead to a lot of litigation over what is a good cause exception in determining it. And there is none in this case. Another thing, issue that has been raised by the appellant in this case is that we did not raise errors in this case. That somehow this is a frivolous suit.
Again, that gets to the merits,
Right,
right?
right.
And we don't have to decide that.
No, Hormel
Decide
tells you
the
not
consent.
to do that
Right.
once there's consent. But the appellant spent a great deal of time addressing this issue. And I think if you look at our responses, we show that, in fact, there are cognizable errors in this case to be heard.
Would there be anything in your oral argument beyond what you argued in your brief on the documented errors?
No.
Right.
No. Except in the reply, the appellant did state that our error was not based on the cost approach and that the county had relied on the cost approach to do it. And that's simply not true. If you look at Index Record 1 and you look at our complaint, our complaint is almost exclusively based on the errors and how it relates to the cost approach. We made that point not once, but 4 different times. There's, I think, a total of 12 paragraphs in the complaint that directly address how the legal restrictions affect the property. And so it's clear that that's simply not true as the appellant had represented. Does the board have, you have any more questions?
I don't.
Okay, thank you.
This case really is more like the Southwest Cotton case that we cited in our briefs, which is a waiver case. And in that case, this court said that once having waived the effect of the mistake, that the litigant was precluded from claiming anything as a result of the mistake that was made in that case. Precluded from claiming anything. So here, the appellee waived the mistake by going to the Board of Equalization, got all of the benefits allowed by the statute for filing a notice of claim of error, even was able to file its complaint in the tax court within the time frames laid out in the statute, suffered no expansion of any of those time limits due to the mistaken mailing. Everything happened within the course laid out by the legislature. So by waiving the assessor's alleged consent, this appellee is precluded from claiming anything now because of it. Appellee made a statement during its argument just now that...
Counsel, before you continue, which case are you talking about when you said Southwest what?
Southwest Cotton.
And that's in your...
It's at least in our reply brief. It might be in our opening brief as well. I can find the site.
That's all right. What's the site?
I only...
Okay, that's okay. If it's in your reply brief. I couldn't find it in your opening brief.
It definitely is in the reply brief, and I'm sorry I didn't copy the whole site for you.
Okay, we can find it.
Okay. Yeah, in the Hormel case, that was Mandamus case. That's why it supports the county here and not the appellee. They pursued the correct remedy. And all we're asking this court to do today is to say that the statute couldn't require mandamus any more explicitly than if it had used the word within the statute itself. Here, the taxpayer knew that was its remedy. It asked for that remedy to the Board of Supervisors, which was the correct place to go first. And then, without the Board of Supervisors even responding to its demand, it went to the Board of Equalization and pled its substantive case. At the Board of Equalization, it did not raise consent as one of the issues that it wanted the board to decide. You can look at that petition that it filed. It is in the record. I believe we attached it as part of our appendices to our opening brief. All they asked for is a different valuation methodology. They did not go to the Board of Equalization with a petition that said, by the way, we want you to hold that the assessor consented to our original notice of claim of error. Now, they did attach a transcript of the hearing where they talked about the consent issue, but there's no certified court reporter present at these hearings, and this was a transcript that they took. We're not arguing with the legitimacy of the words that were transcribed, but you can say anything at a hearing, but you're limited to appealing what you put on your paperwork before you approach that board. And in their petition that got them that hearing, they didn't raise the consent issue. They knowingly waived it, and they can't claim it now. But again, we're not asking that you throw them out. We're asking that you let us in and give the county an opportunity to meet their claim of error, to defend against it, and let them prevail on the merits if they can. They seem to think that they can prevail on the merits. Okay, let's have an adjudication on the merits in the tax court before we grant a windfall refund to one taxpayer in Santa Cruz County, Arizona, where all the other taxpayers in Santa Cruz County are going to have to make up the shortfall for 4 years of retroactive tax refunds. There is a danger here that if the court opens the door for automatic consent on this kind of a time frame with these kinds of equities at stake, that other mistakes might happen in the future. We know that these kinds of mistakes happen. Our case law is full of them. And if we have taxpayers filing notices of claim of error that are not substantiated and flat out wrongly misrepresenting facts, if a mistake occurs, then the burden of that mistake is going to be fait accompli just because of a mistake.
So that's not because of anything we've done, it's because of the legislature's choice to set it up that way.
But, Your Honor, I think there is a very clear way of interpreting the statutory framework here that upholds the goals of the property tax system, which is to ensure that all taxpayers pay their fair share of the tax burden. And that's to look at this statute that we're both relying on and don't take the first clause out of context, but say the second clause is what controls here. And this taxpayer now has the pleasure of proving its case in court. And that's all that the county is asking for here. So unless the court has any questions, I'll give you back 52 seconds of my
I do
time.
have a question.
Okay.
We're not going to let you give us back that.
All right.
I can't find Southwest Cotton in either of your briefs. Now, maybe I'm missing it, but, and, you know, I guess we could try to do some generalized research to find out if we find something called Southwest Cotton, but it would be helpful to me.
Brief on page 12.
Excuse me?
Excuse me, it's in the opening brief, pages 12 and 14. I'm looking at the table of contents.
Okay.
Thank you, counsel.
Pages 12 and 14 of the opening brief.
Yes, Your Honor, at the bottom of page 12, a waiver is a voluntary and intentional relinquishment of a known right or such conduct as warrants an inference of the relinquishment of such right. Southwest Cotton Company versus Valley Bank, 26 Arizona 559. Goes back a little ways. It's a 1924 case, but it is still good law. And it's the one that says once you waive, you're precluded from claiming anything as a result of whatever mistake your opponent made.
Thank you, counsel.
Thank you.
Good argument, folks. We appreciate your time. We appreciate the preparation you put into it and your information you've communicated to us today. We're going to take this under advisement at this time. We will rule in due course. Again, thank you, and we are adjourned.